about legal standards that we use to sort of make war more humane. So I'm going to talk about two areas of law from international law. The first is the jus ad bellum, and this is about the use of force. And essentially, this area of law controls when states can use force against another state. The second is the jus in bello. And so this is often called law of international armed conflict, international humanitarian law, operational law. This is, once you're in an armed conflict, what can you do? And so they're very related, but they're distinct fields. So back in 2011, the Wall Street Journal broke this story. And they had this wonderful quote from an unnamed DoD official, and it was about how we're going to now think of cyber attacks as actual attacks on the United States. And this wonderful quote, which I sort of think was very well orchestrated. If you shut down our power grid, maybe we will put a missile down one of your smokestacks. And this is a very stark thing that's being said here, is if you come in with cyber capabilities, we will reserve the right to respond with force. And I think that this is a very interesting moment, because I think very few people doubted that the United States held that opinion, but this was a formal statement of it. And this is because cyber weapons have been unclear in international law. To use force, the use of force is generally outlawed under Article 2.4 of the UN Charter, but Article 51 gives us this wonderful self-defense exception. And it clearly states if there's an armed attack, you can respond with force. Well, the question is, what is armed? Is a computer virus an armed attack? And it's a question, there's a great deal of literature out there on this particular question. And so the US policy is now that cyber can equal armed. It doesn't always equal armed, but it can equal armed. And the thing that follows from that is that cyber capabilities are weapons. And there are strategic reasons that the United States did this. We have still a very Cold War modeled military. And so strategically, we have a huge dependence on these capabilities. They're ingrained in our system. If we lose our cyber capabilities, we actually lose our ability to mount an active defense. And so we have a traditional force projection. We still have a huge Navy, we've got an Air Force, and we do all the things that we used to do in the Cold War, but we're trying to adapt. But other countries have been developing this idea of asymmetric warfare. They're not stockpiling nukes like we did and Russia did. They're going through different routes. And the one that everybody is going to think of is, of course, China. And Chinese military doctrine very clearly states this idea of we can defeat the superior with the inferior. And so there's this strategic tension going on between a lot of states. And the United States is seeking to protect its interests by making such this declaration. And because it's interesting, states generally wouldn't make this declaration. You'd let it slide. You don't want to let this out, because you might need to use a cyber capability that could amount to an armed attack under your new rubric. So by making this declaration, this idea that it can be an armed attack, the United States has really stepped out and said, look, we know that you're threatening our cyber capabilities. We now will view this as an armed attack. And now, that's not to say that every breach is going to be met with force. There's this idea of proportionality. And so the quote earlier, if you shut down our power grid, a power grid has real-time effects for a city. And so that may get responsive force. If you shut down an economic network or a financial network, probably not going to amount to force. There's this spectrum there that's going to be balanced. So there's this duty. I don't know why I all capped conflict there, sorry. There's this duty in Additional Protocol 1 to the Geneva Conventions, and those of you that are familiar with this area of the law will immediately note that the United States is not party to Additional Protocol 1. However, we actually put this duty into our law before Additional Protocol 1 ever came out, or not into our law, into defense policy. And it's this idea that when you come up with new weapons, you should make sure that they're humane, that they comply with the jus in bello, that operational law. And so the ideas behind this, you have some primary concerns. You want to reduce the suffering of combatants. You want to reduce civilian deaths. And you want to reduce the damage to civilian property. It's this idea that war is an inhumane thing in general, but we can make it more humane if we set up some basic rules that the parties agree to abide by. So following this DoD admission that we're going to view cyber attacks as an act of aggression, or that we can view them as such, we get this wonderful Air Force instruction, 51102. And it reflects this change that the Air Force definition of weapon, and it requires a legal review of cyber capabilities intended for use in cyber operations. So what we have here is the Air Force saying, okay, if we're going to view a cyber attack as an act of aggression, that means we actually have to look at our own capabilities and figure out which ones of those could be considered an act of aggression when used on another state, and whether or not those comply with the laws of armed conflict. So, to be reviewed, you have weapons, and these are devices designed to kill, injure, disable, or temporarily incapacitate people, or destroy, damage, or temporarily incapacitate property and material. These are guns, these are grenades, these are that sort of thing. But what they did in this instruction is they added cyber capabilities, and this is any device or software payload intended to disrupt, deny, degrade, negate, impair, or destroy adversarial computer systems, data, activities, or capabilities. But they were very clear that this does not include cyber tools, devices, software that provide access to adversarial computer system for data exploitation. So what we've done here is, of course, protect our intelligence community from falling under this idea of that might be an armed attack if you're going out and spying. So spying is still protected. You don't have to do this review for spying capabilities. But for capabilities that are going out and affecting other systems and other networks, well, you have to do this legal review. So it's a three-step process. The first question is whether it's de facto illegal, whether there is a specific rule of law that says this is illegal. The next is, does it cause superfluous injury to combatants? And the third is whether it's targetable, whether it can distinguish between civilians and combatants, because you can't attack civilians. So I'm going to go through these three questions. The first two, I think, raise minimal problems for cyber capabilities. But I think that the third one raises a lot of questions that are going to be difficult to deal with. So the first is whether there's a specific rule of law that outlaws these sorts of capabilities. And so when you're talking about conventional weapons, you have a series of treaties. Biological Weapons Convention, Chemical Weapons Convention, and the Convention on Conventional Weapons, which is a wonderfully named convention. And so all of these lay out very specific rules about weapons that are illegal. And in the Air Force instruction, also, domestic law restrictions can apply. Now, there are no treaties that limit any sort of cyber capability right now. And I spent a solid afternoon with the U.S. Code and couldn't find any sort of domestic law restriction on the weapons that the military can use, whether cyber or conventional. So I think that right now this is a very this is a place where you're not going to run into a lot of trouble. Now, 20 years down the road, we may begin to see conventions come out. The issue, though, is, of course, this is high technology, and it's always changing, and it's very difficult for states to negotiate treaties on things that are constantly changing. Because either you lock yourself into technology or you preclude technologies that may come out later. And states are very reluctant to do that. So there are no specific rules of law. Now the second is this idea of unnecessary suffering. And this is a harm greater than that unavoidable to achieve legitimate military objectives. And that's a statement from the International Court of Justice. And what this is going to, or speaking to, is this idea that we don't want to really hurt combatants more than we need to. Yes, you can kill a combatant, but you don't want to cause them unnecessary suffering. And the best examples of these are actually the things that are outlawed here. And the one that I like to use, because when we talk about biological and chemical weapons, we all kind of have a gut instinct of why that's bad. But the Convention on Conventional Weapons has protocols with it. And one of the protocols outlaws blinding laser weapons. And so there's this moment where it's a non-lethal weapon. The idea is that a blinding laser weapon is a non-lethal weapon. But because it causes permanent blindness to a combatant, who will then leave the hostilities and be left with this debilitating problem for the rest of his life, we think that this is unnecessary suffering, and so we have outlawed those weapons. You can still shoot him, and that's fine, he can die, but this idea that you don't want to unnecessarily debilitate combatants post hostilities.